Okay, so we don't have to be in a crisis. I know I don't have too much time. I'm not going to try to pressure this. I'm going to try to speak slowly and steadily. I already know your English is good enough to understand this, but you should have already been provided with the translator if you needed to understand this. Right to counsel, privilege against self-incrimination, confrontation of witnesses. Failure to give a suspect Miranda warnings does not require suppression of the physical fruits of the suspect's unwarned but voluntary statements. I'm just going to read them. You're going to have to apply the next steps. United States versus Patain, 2004. With respect to an accused who does not have the assistance of counsel at a plea hearing, the federal Constitution's Sixth Amendment is satisfied when the trial court, before accepting a guilty plea, informs the accused of 1. The nature of the charges against the accused, 2. The accused's rights to be counseled regarding the plea, and 3. The range of allowable punishments attendant upon the entry of a guilty plea. The Sixth Amendment does not require the trial court to warn the accused that 1. Waiving the assistance of counsel in deciding whether to plead guilty entails the risk that a viable defense will be overlooked, or 2. By waiving the right to an attorney, the accused will lose the opportunity to obtain an independent opinion on whether, under the facts and applicable law, it is wise to plead guilty. Iowa versus Tovar, 2004. A criminal defendant's Sixth Amendment right to self-representation at trial is not absolute. For 1. The defendant must voluntarily and intelligently elect to conduct his or her own defense. 2. The defendant must be made aware of the dangers and disadvantages of self-representation. 3. A trial judge may properly terminate self-representation if necessary, even over the defendant's objection. And 4. The trial judge is under no duty to provide personal instruction on courtroom procedure or to perform any legal chores for the defendant that counsel would normally carry out. Moreover, a lay appellant who had represented himself at a state criminal trial and who wished to do so on direct appeal from conviction was not deprived of a federal constitutional right, where state courts required him to accept a state-appointed attorney on appeal. Martinez versus Court of Appeal, 2000. The right to counsel under the federal Constitution's Sixth Amendment attaches only at the initiation of adversary criminal proceedings. Before proceedings are initiated, a suspect in a criminal investigation has no constitutional right to the assistance of counsel. Davis versus United States, 1994. Invocation regarding one offense of the right derived by Miranda versus Arizona, 1966, 384 U.S. 436, 16 LED 2D 694, 1966 U.S. Lexus 2817, 86 SCT 1602, from the federal Constitution's Fifth Amendment privilege against self-incrimination to the assistance of counsel during custodial interrogation is not offense specific. Once an accused invoked the Miranda Fifth Amendment right to the assistance of counsel for interrogation regarding one offense, the accused may not be reapproached regarding any offense unless counsel is present. McNeil versus Wisconsin, 1991. Under the federal Constitution's Fifth Amendment privilege against self-incrimination, persons questioned must be warned prior to any custodial questioning that they have a right to remain silent, that any statement they do make may be used in evidence against them, and that they have a right to the presence of an attorney, either retained or appointed. Pennsylvania versus Muniz, 1990. Unless a suspect voluntarily, knowingly, and intelligently waives his or her rights under the federal Constitution's Fifth Amendment privilege against self-incrimination to remain silent and to have an attorney present during custodial questioning, any incriminating responses to questioning may not be introduced into evidence in the prosecution's case in chief in a subsequent criminal proceeding. Pennsylvania versus Muniz, 1990. The federal Constitution's Fifth Amendment privilege against self-incrimination protects persons accused of crimes only from being compelled to testify against themselves or to otherwise provide the state with evidence of a testimonial or communicative nature. In order to be testimonial, an accused communication must itself, explicitly or implicitly, relate a factual assertion or disclose information, as only then are persons compelled to be witnesses against themselves. Pennsylvania versus Muniz, 1990. Under the federal Constitution's Fifth Amendment privilege against self-incrimination, confessions remain a proper element in law enforcement, and any statement given freely and voluntarily without compelling influences is admissible into evidence. Illinois versus Perkins, 1990. Put a paperclip on that one. Statements taken during legal custody are inadmissible if they are the product of coercion, if Miranda warnings are not given, or if interrogation does not cease when an accused requests counsel. New York versus Harris, 1990. Take the paperclip off and consult in Reed Charity Colleen Krause. A more searching or formal inquiry is required before permitting an accused to waive the right under the federal Constitution's Sixth Amendment to counsel at trial than is required for a Sixth Amendment waiver during post-indictment questioning, not because post-indictment questioning is less important than a trial, but because the full dangers and disadvantages of self-representation during questioning are less substantial and more obvious to an accused than they are at trial. Patterson versus Illinois, 1988. In order to protect the Fifth Amendment privilege against self-incrimination in custodial interrogations, the police are required, prior to the initiation of questioning, to fully apprise a suspect of the state's intention to use his statements to secure a conviction, and must inform him of his rights to remain silent and to have counsel present if he so desires. Also, the police must respect the suspect's decision to exercise the rights outlined in these warnings, so that if the suspect indicates in any manner, at any time prior to or during questioning, that he wishes to remain silent or states that he wants an attorney, the interrogation must cease. Moran versus Burbein, 1986. The Miranda exclusionary rule may be triggered even in the absence of a violation of the Fifth Amendment, which prohibits use of the prosecution in its case in chief only of compelled testimony. Failure to administer Miranda warnings creates a presumption of compulsion, and consequently unwarned statements that are otherwise voluntary within the meaning of the Fifth Amendment must nevertheless be excluded from evidence under Miranda, even as to a defendant who has suffered no identifiable constitutional harm. Oregon versus Elstad, 1985. For purposes of determining under the Due Process Clause of the Federal Constitution's 14th Amendment whether a state criminal defendant's confession has been coerced, 1. A finding of coercion need not depend upon actual violence by a government agent. 2. A credible threat is sufficient. 3. Coercion can be mental as well as physical. And 4. The blood of the accused is not the only hallmark of an unconstitutional inquisition. Arizona versus Fulminante, 1991. Absent deliberately coercive or improper tactics by police in obtaining an initial statement, the mere fact that a suspect has made an unwarned admission does not warrant a presumption of compulsion. The subsequent administration of Miranda warnings to a suspect who has given a voluntary but unwarned statement ordinarily should suffice to remove the conditions that precluded admission of the earlier statement. In such circumstances, the finder of fact may reasonably conclude that the suspect made a rational and intelligent choice whether to waive or invoke his rights. Oregon versus Elstad, 1985. Just in case.